You're watching C-SPAN, America's Network. Coming up next, a hearing before the House Judiciary Subcommittee on Monopolies and Commercial Law. Members look at the specific example of the Goodyear Company merger as they consider whether mergers and takeovers are healthy for American industry.
The subcommittee will come to order. Mr. Seiberling.
Mr. Chairman, I ask unanimous consent that the committee permit the meeting this morning to be covered in whole or in part by television broadcast, radio broadcast, and/or still photography pursuant to Rule 5 of the committee rules.
Without objection. Without objection, so ordered. This subcommittee is very much concerned about the federal government's policy on mergers and acquisitions. And I might point out that it's very much the business of the Monopoly Subcommittee of the House Judiciary Committee if this policy works out to damage competition. This administration's policy is new. Never before have we found in either Republican or Democratic administrations where in acquisitions and in mergers the only test is if capital can be raised to make the deal. Apparently, this administration doesn't require the showing of need that it be made that competition is not being damaged. This completely disregards the key antitrust principle that has served this country very well for over 100 years. Capital, of course, is very essential in our economy, but what about the other economic values, our system's other values, such as self-initiative, the worth of small business, building competition and innovation? Should these values be completely ignored in a single-minded focus on whether investment bankers can go out and make a deal? Some say we're looking at the steady dismantlement of American industry, and the question should be asked, is this the road to a healthy domestic economy, and is this the road to competing in world trade? We're going to continue this important public debate on U.S. merger policy and its long-term impact, and we have some fine witnesses that we'll get to in just a moment. I now yield to the very distinguished member from Akron, Ohio, Mr. Seiberling.
Well, thank you, Mr. Chairman. Before proceeding, I have statements here to be submitted by Congressman Dan Daniel of Virginia, Congressman Edward Feehan of Ohio, and 10th Ward Councilman Jeff Fusco of the city of Akron, and I ask unanimous consent they be included in the record following my prepared opening remarks. And I offer them now for that purpose and ask the staff to give them to the clerk. Mr. Chairman, I think one can begin to gather from the attendance here today the degree of interest in this issue in, may we have order, please, Mr. Chairman?
Subcommittee will come to order.
I think we can begin to gather the degree of interest in this issue in Akron and the Akron area, as well as the entire rubber industry. The entire community of Greater Akron is in a state of shock. I can't recall anything like it in my experience since the attack on Pearl Harbor on December 7th, 1941. Among other things, this is evidenced by the petitions that were gathered in the last few days in the Akron area expressing support for Goodyear and opposition to this takeover. I have them before me. There are 36,000 signatures on them. I'm not going to offer them for the record, but that gives some idea of the degree of concern among people generally in our community. The question is this concern justified? Mr. Chairman, I would like to read a few excerpts into the record from some of the hundreds of letters addressed to me and to the Akron Beacon-Journal on this subject. And let me start out by reading a couple of paragraphs from the editorial of Friday, November 14th, 1986, from the Akron Beacon-Journal, and I quote, "President Reagan's administration, which has relaxed the government's approach to antitrust laws, ought to take a close look at the Goodyear situation as well as other takeover attempts. No one in the administration should be complacent about American capital moving overseas. No one should be complacent about well-managed American companies being eaten up by sharks whose chief interest is quick profits. The Goodyear situation for this community and many others shows clearly that something is wrong in the economic system. The United States has thrived in part because companies such as Goodyear planned for the future. Goodyear is now being severely penalized for that kind of planning. Many in the Akron area are justifiably nervous about the consequences for this whole region as well as for Goodyear." End of quote. Let me just read a few excerpts from some of the hundreds of letters that I have received and that the papers received. One goes as follows. "Goldsmith's interview with Beacon-Journal reporters was a smokescreen to conceal his real motive: control Goodyear, cut it into pieces, and walk away with a bundle. Look at his track record. He used $661 million in borrowed money to buy Diamond International Corporation in 1981. He sold off all parts for approximately $600 million. He still holds 1.7 million acres of timberland, now worth more than $700 million. More recently, Goldsmith gained control of Crown Zellerbach Corporation. He forced a restructuring that netted him 1.9 million acres of timberland, $91 million in cash and other holdings. The remainder of Crown, including its paper business, was sold." That's the end of the quote from that letter. Let me read from one or two others. Another writes, "It absolutely sickens me when I pick up the newspaper and read about Sir James Goldsmith. How this man sleeps at night is beyond me. He is tearing up lives the way most people tear up paper. Goldsmith, a man who admittedly knows very little about the tire and rubber business, has decided that Goodyear should get back to its core business." Another letter writes, "Sir James Goldsmith's actions feel like an act of war to Akron. Why is England, our oldest and best ally, allowing one of her knights to attack us? Why is our government allowing time after time across America our vital industries and defense industries to be raped and pillaged? What needs to happen before our government protects us against these acts of war?" Another says, "If Goldsmith really wants a stronger Goodyear, he will fade away. He admits knowing nothing about the rubber or aerospace industries, but insists on trying to dictate corporate policies to Goodyear, a company he also admits is the best-run rubber company in the world. The real sad note to this story is a federal economic policy that allows a single foreigner to reap billions of dollars and leave entire U.S. communities devastated in his wake." And I might add a thought of my own. It isn't just foreigners that we have to be concerned about. There are plenty of Americans who are involved in this takeover operation, too. I have another letter from that a woman wrote to Senator Dole and sent a copy to me that says, "Why should a company be penalized for excellent management? Some would say capitalism at its best. This excellent record has now become a threat to our community and society. Capitalism, the basic principle of American business, and America now being undermined by an outsider. How can Congress permit this kind of marauder to wipe out an integral part of our community or any community?" Well, I could go on and on. Some of these letters are extremely touching. Widows who fear for their pensions, retirees who are concerned. I have one from a retiree who says, "I am a retiree and I spent 39 years of my life with Goodyear and feel very close and a deep sense of belonging to the Goodyear family. Please do your best to stop this, Mr. Goldsmith." So that's why we are here. I will offer these letters for the record. And, Mr. Chairman, I'd like to ask unanimous consent to proceed for 2 additional minutes, if I may.
The gentleman is recognized for 2 additional minutes. We have a lot of witnesses, and we have a number of members who want to make very short statements, so let's move along.
Well, I thank the chairman. Let me simply say that the basis for this fear is not just a public relations campaign. The basis is the record of what has happened to dozens of other companies which have been target of takeover artists, including those who've been targeted and taken over by Mr. Goldsmith. Invariably, these activities have resulted in a loss of jobs, weakened competitiveness, and in many cases, the complete dismantling of the company. I will offer also for the record, Mr. Chairman, a paper by a Cleveland lawyer, Lee B. Trevor, which outlines in great detail the kind of drastic contractions and bad business effects, and even the wiping out of whole corporations as a result of this takeover mania. The title of it is Hostile Takeovers, the Killing Field of Corporate America. Goodyear is not just any company. Goodyear has been part of the American scene throughout the 20th century. It helped make the auto age possible. It is not only the largest rubber company, it is the best managed, most competitive, most technologically advanced, and it is organized on a global basis and has been for over 50 years with over 100 plants all over the free world. So this is a company that by Mr. Goldsmith's own admission is a well-managed company, and yet it is being penalized because those very policies that give it the kind of competitive strength that it has demonstrated time and time again open it up to this kind of assault from the rear by the financial community. It is high time that this government made that kind of activity illegal, and that is the question before us. Obviously, we can't much longer tolerate this, or we will find that we have closed the barn door after most of the horses have gone. Thank you very much, Mr. Chairman.
We're honored to have 2 members of the other body here today. The chair recognizes for a statement the distinguished senior senator from Ohio, Senator Glenn.
Chairman, I appreciate that very much in allowing us to testify, and I'll keep my remarks short because I know the chair's desires to have the witnesses have our hearing today focus on the people from outside the Congress here, even though we have a vital interest here. I would like to ask unanimous consent to submit a longer statement for the record if the chair would permit. Mr. Chairman, I would like to ask that a longer statement be included in the record.
Without objection, Senator.
All right,
so
and I'll
ordered.
keep my remarks short so we can get the testimony of those who are directly involved here. But I think this is of overriding interest. And if corporate raiding were simply a game involving only wealthy financiers, we wouldn't be here today. But hostile takeovers inevitably involve the workers, the company, the community, and often in very, very negative ways. Unfortunately, corporate raiders typically take over companies only to break them up, dispose of the most profitable divisions in order to realize an immediate profit. And for that same short-term reason, they often immediately cancel or drastically reduce the budgets of departments that are vital to the long-term health of the company. 2 examples are what happens in research and development. We're in an internationally competitive position around the world today. We have to have the very best of research. Goodyear, as one company, has stressed their research, and they've been able to stay in the forefront of American industrial power because of that research. That's a natural area to be knocked out. Advertising is another. No modern company operating here or around the world can really operate successfully without advertising and keeping their name known before people around the world. And those are 2 areas that in a company like Goodyear, I don't know the amount. We'll probably have testimony on that later on, but I would guess we're probably talking $500–600 million that could immediately go into the pockets of those who are interested in a takeover effort if those 2 areas were cut drastically. As an Ohio senator, I, like Congressman Seiberling and Senator-elect Sawyer, are particularly concerned about this particular position. We've also had a recent past episode in Ohio with Owens Corning out of Toledo, in which the same thing took place, in which we already have lost thousands of jobs in Ohio because of Owens Corning, the attempted takeover there. So that's not something that is just theoretical. That's something that has already happened to us there. Now, what we had in a case like Goodyear is the tire business was going down, was becoming more competitive internationally. They were having difficulty. Goodyear very wisely decided to diversify, get into some other areas, aerospace and so on. Now they did that. Now those are areas now that because of even the rumors and the actions taken so far, Goodyear is having to retrench, go into a defensive position, sell off those things which were going to be their diversification specialty areas into the future. That does not do the company any good, it does not do the workers any good, and it does not do the community in Ohio and the United States any good. Now, whatever legislation we pass, I feel has to be two-way. I don't think we can just say foreign investors cannot put together a consortium, come in here and take over major American firms on some sort of a pillage mission and take off the profit of those firms. I think we ought to do something about our people going the other direction, too. And maybe we have to leave that up to others over there to defend for themselves. But in a situation like this, I just don't think it's right. As circumstance would have it, this morning I was talking to a friend of mine who, not just a couple of years ago, headed up one of the major investment banking groups in Wall Street. And without even knowing I was coming to this hearing, he asked what we were doing about the Goodyear situation because he had followed it. He knows the company very, very well. And he made the comments even before I said I was coming to this hearing this morning, and this occurred just about a half hour ago. He said that this was a company that he thought had been absolutely first-rate in taking a declining industry, one that was more competitive, and in switching their efforts, diversifying into other areas. Now they're being faced, after they had done a good job, with a potential corporate takeover that was going to devastate the community, the workers, the state, and he thinks it's a very fine company that's about to be messed up by all of this business of international arbitrage or whatever you want to call it. That's much in the news these days with the Boesky case in New York and so on, and apparently more heads to fall on that one. But when we have a company like this that's been well managed and we set about destroying that, the huge amounts of mid-management build-up to take care of the diversification, all the employees that are involved with that whole thing, they've done a good job. We come in with whatever the method of financing will be, whether it's going to be junk bonds or funny money of one kind or another, as it's called on Wall Street. To me, that's unconscionable. I hope that the least we could do is pass some legislation that requires a lengthy delay before things like this can be consummated. I think that might be one of the best things that we could do. I question whether it's good public policy to subject communities like Akron and Toledo to the dreadful uncertainty of major job losses, economic ruin, because of the actions of corporate raiders who have no ties to those communities, and particularly with a well-managed firm like Goodyear that is an attractive target for a corporate raider. So it's clear that Congress needs to fully explore this problem in all of its complexities. Today's hearing is an important start in addressing these issues, and I'm pleased to participate in it. I appreciate your putting my long statement in the record, and I appreciate your willingness to listen as I tried to talk very fast here to cram as much in a short period of time as I could. I think this committee is particularly well suited to take action in this area. Look forward to working with you from the other body.
Well, thank you, Senator Glenn. That's a very helpful statement. We are also honored to have one of the really great experts and great senators from the state of Ohio, Senator Metzenbaum.
Thank you very much, Mr. Chairman. I want to compliment you and Senator and Congressman Seiberling and the other members of this committee for taking your time out during the recess to conduct this hearing. I think it indicates a sense of commitment for which all of us in Ohio are very indebted to you, but I think the entire American business community should be indebted. There's no question about this company being a good corporate citizen, good in its contributions, good in paying its taxes, being well run, true asset to the Ohio community, great asset and a major asset to the Akron community. Very good point. Politicians never should have to have that suggested. Thank you, Congressman Seiberling. Today we are examining a situation which could bring substantial harm to this important company and the family's entire community. Sir James Goldsmith, heading a small group of investors, has bought up 11.5% of Goodyear stock in the past 2 months. And he says he may buy more in an effort to own Goodyear. He is doing that which he has a legal right to do under the laws as presently written. The company, in an effort to prevent this hostile takeover, is considering selling off its Akron-based aerospace division, its oil and gas subsidiary, Celeron, and its motor wheel divisions. By selling these divisions, Goodyear can raise the necessary capital, buy enough outstanding stock to prevent the takeover. To me, that's not the way the American economy should run. The basic issue in this matter is this raid on Goodyear going to strengthen the company? Is it going to help the employees? Is it going to help the community? Is it going to help the shareholders? Now, a takeover would not replace bad management with good management, because it's an agreed fact that Goodyear has good management. It would not make an unprofitable company profitable. Goodyear already is profitable. Nor would it increase jobs, improve profits, or help Goodyear become more competitive. Instead, it would more likely leave thousands of hard-working employees without jobs and leave Goodyear financially weaker. We have seen case after case of corporate raiders who do not buy companies to make them more efficient or to create new jobs. They buy these companies, then liquidate the assets for quick profit, and sometimes the raiders don't even bother to acquire their targeted companies. Instead, in what is now commonly called greenmail, they announce a planned takeover, buy up some stock, watch the stock prices rise, and then sell off the stock at inflated prices. As a matter of fact, I'm advised that Sir James Goldsmith has indicated that not his intent, nor does he desire to have a greenmail arrangement. But I cannot overlook the fact that in the St. Regis paper matter, he was a participant in greenmail to the extent of a $50 million profit, and the rest of the shareholders of the company and the company itself was left holding the bag. Now, this takeover mania has spawned widespread abuses in insider trading as corporate insiders try to profit from wildly fluctuating stock prices. We need do nothing more than pick up the front page of any paper these days to read about one of the major arbitrageurs in this country and the involvement in which he's gotten himself. I do know this about Sir James Goldsmith. I don't know what his plans are. I think we are entitled to know his plans. I know that after gaining control of Crown Zellerback Corporation, a $3 billion paper and timber company, he quickly sold off the paper division to another company. I do know that people lost their jobs at Crown Zellerback's corporate headquarters in San Francisco after his actions. He has not, as of this point, made the case that his acquisition of Goodyear will make it a stronger company. All the evidence so far is that this kind of raid, which I again parenthetically say is legal under the present laws, will do far more harm than good. We have seen dozens of acquisitions that have gone sour. And what has occurred is that at this point in time, those of us who have attempted to move forward to do something on this issue have had a kind of resistance from the administration. The administration has taken the position that they will not intervene. And realistically speaking, without the administration's support, it's very difficult to pass legislation in this area. And as a matter of fact, the Antitrust Division, and this is not at this point evident on its face that it is an antitrust issue, although we do not know what all of Mr. Sir James Goldsmith's other holdings are, it may be an antitrust issue, and that we can only determine after we examine the evidence further. But as I see it, and I think that's the issue before us today, Congress must be willing to tackle the problem of unfair and harmful takeover tactics. The administration's irresponsible, hands-off approach doesn't make sense. The business community must join with those of us in the Congress who are willing to zero in on this issue, and I have discussed this subject with Mr. Mercer. If we're willing to zero in on the issue, then we ought to be able to work out with the administration and the corporate community as well a legislative approach that is fair, that is not one-sided, and that brings about a decent and proper solution so that all parties concerned get a fair break. There are specific steps that we can take. Unfortunately, when we were moving forward in this area in the last session, and Senator D'Amato had made a public commitment that we would have a markup of the bill, Senator D'Amato failed to live up to that commitment, and we never were able to bring the bill to the floor or to get any action on it. We can eliminate the worst takeover abuses such as green mail, two-tier tender offers, and certain types of junk bond financing. And junk bond financing have much to do with some of the issues involved in these takeovers. We can strengthen the Hart-Scott-Rodino filing requirements by giving the antitrust agencies more time to review large mergers. By closing loopholes that allow some companies to ignore the filing requirement, and by requiring the filing requirement to occur without having that 10-day window in which an acquisition-minded raider may have enough time to acquire the stock, we should reduce that window to 2 days. We had legislation in this area last time, or we could not move it. But in the final analysis, our principal concern is not the opportunity for someone to make a quick profit, the concerns of corporate management, or the rights of shareholders. It is the welfare of the whole community, those who depend upon companies like Goodyear for jobs, for economic stability, or for better quality of life. Mr. Chairman, I am concerned that if the Congress doesn't move promptly, and hopefully with the cooperation of the administration, and hopefully with the cooperation of the United States Chamber of Commerce, the National Association of Manufacturers, the Business Roundtable, the major labor organizations in this country, if we don't move promptly to do something about this issue, I'm afraid that someday some of the pillars of the free enterprise system will no longer be here, and we will have to start from scratch in order to build up companies like Goodyear all over again. Mr. Chairman, thank you for your cooperation.
Thank you very much, Senator Metzenbaum. We have a great number of members who have asked to be heard, and I love them all dearly, and I'd like to listen to them all day. We are going to give each of them about 30 seconds and ask them to please do the very best they can. We welcome the very distinguished Congresswoman from Maryland, soon to be a member of the other body, Barbara Mikulski.
Thank you very much. Thank you very much, Mr. Chairman. And I ask unanimous consent to revise and extend my
Without
remarks.
objection.
And also unanimous consent to include the remarks of Senator Paul Sarbanes,
Without
who, like
objection,
myself, opposes this hostile takeover. Thank you very much, Mr. Chairman, and I'm glad to be here today, not only in my role as a Congresswoman, but as a Senator-elect, and perhaps helping this Judiciary Committee and the other body to come to some new legislative conclusions. I oppose the current attempt by Sir James Goldsmith to acquire Goodyear because I believe it represents the most serious threat to job security of the people of Goodyear and the people of Kelly Springfield in my own state of Maryland. Kelly Springfield is one of Western Maryland's remaining major industrial employers of 1,700 people. This hostile takeover attacks not only a great corporation like Goodyear, but its subsidiaries and local communities. Unfortunately, this takeover is not an isolated instance. It is symptomatic of an increasing trend towards corporate strip mining, where a productive company is stripped of its most valuable assets and other assets are discarded. The asset that's most frequently discarded is the employees. And in the high-stake games to acquire, preserve, control, communities, families, and productive communities across America are being sacrificed. Mr. Chairman, I know that I have 30 seconds, and that's why I'd like to advocate not only the expiration of new laws, but the enforcement of existing laws. I believe the SEC should prevent any more steps by would-be owners of Goodyear for 90 days to fully investigate the national security implications of the acquisition of a foreign investor. I believe Sir John Goldsmith and all of his partners should provide full disclosure to SEC as required under the Williams Act so that the nature of the investors group can be more fully realized. Secretary of Commerce Baldridge should begin an investigation under the 1962 Trade Expansion Act to determine again the national security implications of a foreign-controlled Goodyear. But most of all, Mr. Chairman, I think Congress needs to take a good look at what we call industrial piracy, where people come in and raid good companies not to create new wealth, not to generate jobs, but to profiteer and be parasitic off of the work and wealth of others. I look forward to working with you in the other body to deal with these most significant issues. And thank you for the time afforded to me by this committee.
Thank you very much, Congresswoman Mikulski. We also welcome for a 30-second statement the Congresswoman, gentlewoman from Ohio, Ms. Okar.
Thank you, Mr. Chairman. Thank you for having this hearing. I want to join my colleagues, my two senators in particular, Congressman Seiberling and Congressman-elect Tom Sawyer, in expressing my outrage at this rising national illness. Corporate America has allowed itself to be taken hostage by the corporate raider. Profitable companies are being driven into debt, American jobs lost, American businesses are being taken overseas, all so a few enormously wealthy individuals can add more to their personal fortunes. This scourge must be brought under control. It's my hope, Mr. Chairman, that this hearing is the first step to that end. I certainly agree that corporate mergers and acquisitions have an important place in the business world. The threat of a possible takeover ensures that corporations do not become complacent and lose their competitive edge, that management will remain tough and profit motivated. However, the newest strain of corporate raider needs to be eliminated. For the raider who focuses on a healthy and profitable company and forces it to defend itself at great expense is nothing more than a parasite. This raider buys large blocks of stock in the target company, then forces the company to try to raise the price of its stock, usually at great expense, and when the stock goes up, the raider sells at a huge profit. The company is left with a large debt and suffers irreparable damage. This is the fate Sir Goldsmith is attempting to impose on Goodyear Tire and Rubber, and I say it's time to say no. Another implication of Sir Goldsmith's action is the threat of his basing Goodyear overseas should he be successful. American jobs in over 35 cities could be affected negatively by this kind of mood, and we need to take action now to save American jobs. It's high time we expanded our laws to protect the American communities and workers, not just the shareholders' investments. We need to examine the wisdom and long-term effect of allowing foreign interests to acquire key American industries and how it will impact our international competitiveness. I feel it's time for Congress to act to protect American business with the marooting of the raider, and especially the foreign raider. And I want to ask unanimous consent that my full statement be submitted in the record, and thank you again for your courtesy, Mr. Chairman.
Thank you very much, Ms. Okar, for a very helpful statement. I ask unanimous consent that the statements of Senators Dole and Metzenbaum, both of the great state of Kansas, be admitted into the record at this point. And we welcome for 30 seconds the Congresswoman from Maryland, Ms. Byron.
Thank you, Mr. Chairman. I'm only sorry that we have to hold this hearings today. Everybody else has thanked you for holding them. I'm just sorry that we have to have them today. And I, too, will be very brief. I would like to submit my statement for the record.
Objection.
I'm certainly not here today to tell this committee about the intricacies of corporate takeovers, which is an area that I am no expert in at all. What I really am here to tell you about is an area of Western Maryland which I represent that has had some very hard economic times, and the impact that this takeover will have on that community. The Kelly Springfield Tire Company, which is located in Cumberland, Maryland, a subsidiary of Goodyear, currently employs, as Senator Mikulski has said, 1,700 people in Western Maryland, West Virginia, and Pennsylvania. It's estimated that the Kelly Springfield payroll generates over $54 million in expendable income to Western Maryland, and it provides $1.2 million in local property taxes and $400,000 in state taxes. These may not appear to be significant to those who exchange millions of dollars at the bat of an eye, but to the thousands of families in the Cumberland area, keeping the Kelly Springfield Company plant open means keeping their families, their schools, and their way of life intact. In the past year, there have been considerable sacrifices on the part of the union workers at Kelly in terms of accepting lower wages to keep the plant competitive. Both the state and the local governments have done an enormous amount of work and their share with management to ensure that the plant remains open through the enterprise zone legislation and other tax incentives that this Congress has passed. This represents an extraordinary effort that, in my opinion, will have been for absolutely nothing if the administration permits the takeover to be effective. I've been a strong supporter of efforts to permit the market to operate freely and excessive government regulations, And I still believe that there's an important role that the federal government must play in weighing the advantages and the disadvantages of such corporate takeovers. One hears that such mergers may make a company more efficient, but what is that in this respect? Its ability to generate more capital, the ability to generate jobs. I hope today's hearings will focus on those issues, and I thank you for your time.
Thank you, Mrs. Byron. The distinguished congressman from the state of Virginia, Mr. Daniels, we welcome you for the ironclad 30-second statement.
On behalf of the 2,200 employees of Goodyear in the city of Danville, the district in which I have the honor to represent, I wish to express appreciation to the chair and to Mr. Seiberling for making this hearing possible this morning. I think in light of the circumstances that developed over the weekend, Mr. Chairman, with Mr. Boesky, that we should write the Department of Justice and SEC and demand that no further action be taken on any merger or takeover pending the outcome of that case. Thank you very much.
Thank you. An able and distinguished member of the Monopoly Subcommittee is the gentleman from Kansas, Mr. Glickman.
Chairman, and I appreciate Mr. Seiberling's leadership and your own in holding this hearing. I would ask unanimous consent to my entire statement appear on the record, and I would just make two quick comments. One is that we have a Goodyear plant in Kansas that employs about 2,000 people. Congressman Slattery represents that plant. Because of the importance of the issue to Kansas, Governor Carlin has asked me to include a letter in the record that he wrote to me on the subject, and I would ask that that would be included as well. I would just make 2 points. One is I'm not going to sit here and bash Mr. Goldsmith. I think he's probably doing what at least the law may or may not permit, and that's something for us to determine. I am going to bash the Department of Justice, however. I think its complete disregard of antitrust prohibitions, as well as the Securities and Exchange Commission and the Justice Department's disregard of the provisions of the securities laws, only fuels the perception that competition no longer is of value in our society. And I think that Mr. Goldsmith and others look at our government as having totally benign neglect in terms of enforcing the laws. So they come right in, as any capable and creative entrepreneur would probably do. And so therefore I think that one of the things we have to deal with is the ability of our government to enforce its laws and protect its citizens. Those laws are on the books. The capitalist system works only if there is no monopolistic practices occurring. Those are happening, and they are fueling speculative practices. They're fueling practices where shareholders and workers and employees and citizens have no idea what these people are going to do to them. But let's put the blame where it lies, and that is on a government which does not properly enforce the law. Thank you, Mr. Chairman.
Thank you. The gentleman from Ohio, a member of the full Judiciary Committee, Mr. DeWine.
Thank you very much, Mr. Chairman. I want to thank you for inviting me to participate in this very important hearing today. I am here today principally because of a concern for jobs in the state of Ohio. We have a very successful Goodyear industrial belt plant in my congressional district in Marysville, Ohio. That plant employs almost 300 people. They are the only U.S. maker of steel cable conveyor belting. I am most concerned with the possible impact any planned takeover of Goodyear could have on these jobs and other Goodyear jobs in the state of Ohio and around the nation. I think we should be interested, Mr. Chairman, in Sir James Goldsmith's takeover history. Is there a pattern of improving companies? Is there a pattern of making them stronger, making them more competitive? Or is there a pattern of dismantling and discarding? What are Sir James's plans in the event he does gain control of Goodyear? Mr. Chairman, this is not a partisan issue. This is not a Democrat or Republican issue. I believe this whole issue of hostile takeovers needs to be re-examined by the Congress. I do not believe we can continue to close our eyes to the very real adverse impact these takeovers are having on our economy. The answer may or may not be in antitrust remedies, but I do think there are avenues available for dealing with this problem.
Thank you. The gentleman from Kansas, Mr. Slattery, is welcomed and recognized for 30 seconds.
I thank the chairman, and on behalf of the 2,300, I thank the chairman very much for calling this hearing, and on behalf of the 2,300 Goodyear workers in Topeka, Kansas, I would like to express my gratitude to you for focusing on what I think is going to become an increasingly important issue in the next Congress. Mr. Chairman, I hope that this hearing and other hearings held by this committee and perhaps the Energy and Commerce Committee and other committees of appropriate jurisdiction will focus on several very important aspects of this whole concept. First of all, I think we need to focus on the question of, does the SEC have the capability today and the personnel necessary to effectively monitor these kind of business transactions where we see an individual through shell corporations in the Cayman Islands or in Bermuda or in Luxembourg or a number of other places around the world putting together these hostile takeovers? And the question is, does the SEC have the personnel and the ability today to effectively monitor these kind of situations? The other very important aspect involved in this transaction is the national security implications. Do we need to revisit the question of whether it is appropriate to allow foreign investors, in this case someone from either Great Britain or France, to acquire in a hostile way controlling interest in a company that has very important contracts with our Department of Defense? And I think these are two of the most important questions that we really need to look at as we examine this whole question involved with the Goodyear hostile takeover. So, Mr. Chairman, again, in the allotted time that I have, I appreciate your interest in this, and I think that this hearing will be the first of many this year by appropriate congressional committees to focus on these very, very important questions that are vital to the future of this country's economy. So I thank you very much, Mr.
Slattery.
I look forward to the testimony.
The chair recognizes with pleasure the distinguished gentleman from Wisconsin, Mr. Kastenmeier.
Chairman, I thank you, and I congratulate you on these hearings, as well as John Seiberling, who has, I think, been at the heart of responding to this question of hostile takeover of Goodyear. I, too, have a plant in my district in Wisconsin, Goodyear plant, that may be jeopardized. I would only say that if we, the Congress, do not act, I'm afraid this will go untended as a problem, because we cannot expect this administration to act, we cannot expect the states to act, so ultimately it's the Congress itself, and this is a challenge before us, presumably early next year, to respond to. Now, I was a member of this subcommittee 20 years ago when we looked at conglomerate takeovers in America. We produced a tremendous study, but it didn't have much effect. This time, I suggest the Congress will have to do something which will have effect in terms of this egregious economic behavior. I thank you, Mr. Chairman.
Thank you, Mr. Kastenmeier. Our first witness today is Mr. W. Stephen Cannon, Deputy Assistant Attorney General, Antitrust Division, United States Department of Justice. We welcome you, Mr. Cannon. Without objection, your full statement will be made a part of the record. The 30-second rule does not apply to you, but the 5-minute rule does.
Mr. Chairman, thank you very much. I appreciate this opportunity to present the views of the Department of Justice on merger policy and the long-term competitive health of the United States industry.
Cannon.
Yes, I think it is.
Thank you.
Great, thank you. Merger activities and the merger policies of the Antitrust Division have been of...
Mr. Cannon?
Pardon me?
I'm just curious. The mic doesn't seem to be working very well.
Well,
Can you hear in the back?
Well, the light's on.
Yeah.
Yeah?
And
yeah.
Try to move the mic as close to your mouth
That's
as you can.
an idea.
Thank you.
How about that? Better? Good. As I was saying, merger activity and the merger policies of the Antitrust Division have been of continuing interest to the subcommittee, and rightfully so. Our dynamic economy depends on the efficient operation of markets in response to consumer demand, the perception of that demand by business, and its ability to marshal and utilize available assets efficiently to satisfy that demand. Decisions regarding mergers and acquisitions are thus an integral part of the dynamic nature of markets, and the ability of firms to make and carry out such decisions is essential to the long-term competitive health of our economy. It's now widely understood that mergers can and often do perform beneficial functions in the economy. Of course, it goes without saying that not every merger has the beneficial effects expected by the parties to the transaction. This recognition, however, amounts to saying no more than that business people sometimes make mistakes in merger decisions, just as they make mistakes from time to time with respect to other corporate decisions. That fact is not and should not be the basis for government intervention. In enforcing the antitrust laws with respect to mergers, the government does not and cannot act as a management consultant or investment advisor to second-guess the wisdom of business decisions. Those roles are properly fulfilled by professionals retained for those purposes, and the wisdom of such decisions is ultimately judged by consumers and stockholders in the marketplace. Rather, the government is properly empowered to prevent a merger under the antitrust laws only where there is a demonstrable threat that competition will be significantly lessened by reason of the transaction. The Department continues to apply sound legal and economic principles in analyzing the likely competitive effects of proposed mergers. Among other things, our analysis takes full account of foreign competition, entry conditions, and other efficiencies that could not be realized by any other means than the merger under scrutiny. If, after all things are considered, our analysis leads us to conclude that a merger threatens adversely to affect a market's competitive performance, and I stress competitive performance, either by creating or expanding a single firm with significant market power or by facilitating collusion among the remaining firms, the Department of Justice is ready, able, and willing to seek to enjoin the proposed transaction. I would conclude by stressing that the health, diversity, and richness of our economy is directly attributable to the economic incentives of individuals and firms in maximizing their profits, in meeting the demands of consumers for goods and services. The long-term economic well-being of our industrial and service sectors requires that this process be permitted to continue unfettered by private or governmentally imposed restraints, except in those instances in which unacceptable threats to competition risk undermining the welfare of consumers. The antitrust laws, properly interpreted and applied to mergers, as well as other forms of business decisions, help to ensure the integrity of the process. Mr. Chairman, that concludes my prepared remarks. I'll be glad to answer any questions.
Thank you, Mr. Cannon. I have just one question for you. What is the message sent out to America when inside traders like Mr. Bosky and the investment banking house of E.F. Hutton, who engage in massive illegal practices, are slapped on the wrist and are let off with only fines and consent decrees? Don't you folks in the Department of Justice have some obligation to prosecute these people fully? You would put people in jail who steal $20 from a bank. Tell us, how come?
Well, Mr. Chairman, let me answer that as simply as I may, and that is to say that, at least as my understanding of antitrust laws, that's not an antitrust enforcement question. What I was here today to talk about was the effect of mergers and merger policy.
You mean that there aren't criminal antitrust laws?
Pardon me?
You mean there aren't criminal antitrust laws?
Oh, yes, sir, there certainly are for price fixing, bid rigging, and market allocations, but the type of activity that you're referring to is prosecuted under the securities laws. And, of course, the Antitrust Division of the Justice Department has no oversight on that.
Thank you. Mr. Seiberling?
Thank you, Mr. Chairman. Mr. Cannon, are you speaking for the administration as a whole or only for the Antitrust Division?
Well, I'm speaking for the administration, Congressman Seiberling, but as this hearing relates to antitrust policy, I'm not empowered to speak about other matters.
Do you think that it is the right role for the Justice Department to just stand by and watch American industry being dismantled through financial manipulation? Is that the kind of workings of the free market that you contemplate with complete equanimity?
No, Congressman, our purpose and mission at the Antitrust Division is to make sure that competition reigns supreme in the United States, and that, in fact, consumers are able to get the lowest possible price for the best quality of goods.
Well, I think that's well put. Let me call to your attention the remarks of Deputy Secretary of Treasury Richard Darman made at a speech on November 7th, in which he criticized the tendency of many American companies to be, as he called it, bloated, risk-averse, inefficient, and unimaginative, close quote. And I presume you'd agree that to the extent that his criticism is accurate, that competition is lessened. And is that, would you agree with that?
I'm sorry, Congressman, I don't can follow that.
Deputy Secretary of Treasury Darman, in a speech, criticized the tendency of what he said American companies have to be bloated, risk-averse, inefficient, and unimaginative, close quote. Would you agree that if that, to the extent that criticism is correct, that that means they are less effective in the competitive sense?
Oh, Congressman, I would certainly think that in terms of the marketplace, which we all have to keep our eye on, of course, that the market certainly rewards companies that are able to produce goods efficiently because they can sell them for a cheaper price. And they can outcompete other firms who can't produce them as efficiently. So I certainly think the market would tend to correct any problems.
And to the extent that American companies are not able to compete effectively, I assume the marketplace will be taken over by companies from other countries. Isn't that correct?
Well, there's certainly no question but that certainly in the antitrust area, we look at international markets. Because
does the Justice Department assume any obligation to take into account whether they should try to keep American companies efficient and competitive? Isn't that part of their mission?
Well, Congressman, certainly in the sense as it relates to the ability of firms, whether they be American firms or foreign firms, to provide, as I say, the highest quality of goods and services for the lowest possible price to the American consumer. And American companies are very good at doing that, and they have a long track record of doing that.
And to the extent they're not good at doing that, I presume that at least competition among American companies and by American companies is weakened, isn't it?
Oh, I would think that any firm, be it an international firm from any other country or an American firm, if they are inefficient and cannot compete as well as their competitors, that they will certainly suffer. We don't want the American consumer to suffer. We want the American consumer to get the best deal that it can.
Well, in the end, though, foreign companies are going to serve foreign stockholders and foreign employees, and if American competition was wiped out, they'd then be in a position to provide to charge higher prices, wouldn't they?
Oh, I assume you're referring to some sort of theory of predation, and that
precisely.
Mm-hmm.
Do you agree with Mr. Darman that American companies, many of them, have not sufficiently invested in R&D and know little about foreign countries and concentrate on short-term profits rather than long-term investments?
Well, let me answer your first part of your question first. Let me say that I agree with the Supreme Court of the United States.
Very good of you.
A couple of months ago, in its Matsushita decision, when it discussed this very scenario you're talking about. And it said, of course, that is always a possibility. However, the likelihood of predation in any given market for any given good or service is in many cases unlikely because of the low entry barriers and a number of other factors.
Well, in other words, what you're telling us is that your Justice Department sees no responsibility at all to look at proposed acquisitions to see whether they weaken the competitive strength of the particular company so long as other companies are there to fill the void. That's basically your position, as I see it.
Our position, Congressman, is, and our job is mandated by the Congress in passing the Clayton Act, is to examine any acquisition and to make sure that that acquisition, regardless of who is involved, regardless of the companies involved, does not substantially affect competition, does not reduce competition or tend to create a monopoly.
Well,
that is our mission.
I submit to you that when Goodyear or any other company is weakened by an acquisition of its stock or assets to the point where it can no longer as effectively compete with other companies, that there is a substantial lessening of competition if that is company's a major factor in the market. And it seems to me that's pretty obvious. And a creative Justice Department that was trying to address the problems of today and not merely applying automatically and mechanically past doctrine would be doing something about it. And to the extent that they are not, it does seem to me that Congress does need to make it a little more explicit so they can spell it out for you. But I shouldn't think you really would have to have it spelled out. Thank you, Mr. Chairman.
The gentleman from Kansas, a member of the subcommittee, Mr. Glickman.
Thank you, Mr. Chairman. Mr. Cannon, has there been a filing under Hart-Scott-Rodino by Mr. Goldsmith in connection with this merger?
Congressman, I checked that before I came this morning, not to my knowledge.
Okay. Mr. Cannon, many of the takeovers we are now witnessing are initiated by entities that may be able to take advantage of the so-called partnership loophole contained in Hart-Scott-Rodino filing requirements. I happen to personally believe that that's kind of a sham, but it may be in compliance technically with the law. Do you favor closing this loophole by legislation?
Congress, we haven't taken a position on that. I am generally aware that the Federal Trade Commission has done an extensive amount of work on that question. And I must say I'm not familiar any further than that. We'd be delighted to look at it, but to my knowledge, we have not developed a position on that.
But if, in fact, people are, in a sense, acting in some degree of concert, whether formally or informally, don't you think that we ought to get through the form and get to the substance?
Oh, Congressman, I certainly understand the situation, and I understand there's been a lot of criticism over the last few years of what's known as the partnership loophole.
Mr. Cannon, if by all reasonable standards a company has been run efficiently, if it's retooled to compete with foreign competitors, if it is struck out into new and growing businesses in order to diversify in this world, do you believe that the long-term competitive health of the American economy is strengthened by that company being taken over by a raider and then seriously dismantled, as Mr. Goldsmith very candidly says he's going to do? He's back into tires, and that's it. I want to know if you think that's good.
Congressman, in the sense of getting back to a basic business that the firm was once in as opposed to other lines of business?
Well, I ask if you think the long-term competitive health of America is strengthened. After all, you're the Justice Department. You've obviously got to be concerned about where the country is going, not just with mere technical compliance under the law. I mean, I assume that you have some input as to where you want this country to be 15, 20, 25 years from now.
Yes, sir, that's true.
Okay, so do you think the economy is strengthened by a company being taken over by a raider and then dismantled?
Well, Congressman, we're a little handicapped here because you have to examine every merger on a case-by-case basis. Certainly the Department of Justice does. In one circumstance, it might be competitive and more efficient. For example, a conglomerate which has acquired a number of unrelated businesses over the years to divest some of those businesses. And in fact, if you look at the merger and acquisition activity going on today, a significant percentage of that activity is divestment. It's not acquiring more companies. It's shedding companies that or lines of business that were unrelated to other lines of business and companies. And so in one sense, yes, it may very well be an efficient thing to do. It may very well be a pro-competitive thing to have someone shed or divest a certain part of a certain company. On the other hand, it may be pro-competitive, it may be efficient for one company to acquire another part of another company or an entirely different company because there may be synergies that may be recognized there with increased efficiency, etc. So you really cannot make broad, sweeping generalizations about the desirability of divesting parts of companies or acquiring parts of companies. Well, it really has to be on a case-by-case basis.
Don't you think that part of this is the fact that we have different kinds of business acquisitions? When we have mergers, we have a different set of circumstances than we have takeover attempts or raids. And that your deficiency at the Department of Justice may be that you view all of these things in the same context when in fact you ought to consider a merger differently than you consider a takeover acquisition, and we need to have perhaps more information or more disclosure in that takeover situation than we do in a merger.
Well, Congressman, as you are well aware, under the existing state of the law, when one is challenging a merger under Section 7, one cannot count on a relevant factor being whether or not that is a hostile takeover or a friendly takeover.
I'm asking you from the policy perspective. Don't you think that this ought to perhaps be considered in terms of changing the law to reflect these circumstances?
Well, what I would not want to see the Congress do or the government do is to stray away from the principle which has served this country very well for the last 100 years or so, that competition is the goal of the antitrust laws and the welfare of consumers is the goal of the antitrust laws. And if we have good, hard competition, consumers would be benefited.
My time is out, but I just ask one final question. My colleague, Mr. Slattery, has mentioned the issue of national security. Do you believe there ought to be a national security component in our antitrust laws by which you would get a sign-off from the Department of Defense, the Department of State, or somebody that would deal perhaps with the national security implications of, let's say, a foreign acquisition or even a domestic merger?
I must say that right off the bat, I would stick to my comment that as other factors that don't have anything to do with competition are not well suited for the antitrust laws. There may be national security implications in a merger, one merger or another, but that really has nothing to do with competition.
Thank you, Mr. Chairman.
Thank you.
Mr. DeWine.
Thank you very much, Mr. Chairman. Mr. Cannon, let me ask you this. Would you favor legislation which would require both parties involved in an acquisition to file a statement setting forth specific information about the acquiring entity's plans with respect to the target, its shareholders, its employees, and the community or communities affected?
Congressman, that to me, and certainly gets into the securities area. Of course, under the antitrust laws now, we have our Hart-Scott-Rodino filings, which the parties to a merger acquisition are required to submit. It gives us the competitive information that we need to analyze whether or not the merger is illegal under Section 7. I really haven't thought about that, and
well,
without seeing more specifics, I'd be hesitant to...
Would it be appropriate antitrust analysis of the transaction would help in that regard?
Would you... Yeah, coming in the outline of the proposal...
Yeah, would or would not such a statement contribute, in your opinion, to an appropriate antitrust analysis of the transaction?
In terms of the long-term competitive effect of the acquisition, or... I tell you, we haven't thought about that. As far as I know, we don't have a policy on it. We'd be delighted to see what the Congress suggests, but right now I would hesitate to...
You don't have a position on it?
No, sir, I don't. That's a short answer. We don't.
All right. You mentioned, I believe, in your testimony a moment ago in answer to a question, did you allude to a partnership? You talking about a loophole in the law?
Well, Congressman Glickman was referring to that. There is something known as generically as a partnership exceptional loophole in the reporting requirements of Hart-Scott-Rodino. It's been discussed in the press and elsewhere for a couple of years now, and there is great debate going on as to whether or not, if one forms a partnership to acquire stock of a company...
Well, what is your opinion about that? Is that a loophole or not?
As far as I know, we have not taken an active role in that consideration. We're only aware of what the FTC has done, but certainly before anything would be done, we would be delighted to try to take a position.
Let me read the definition to you. 801.1, except as provided in paragraphs A and B of 801.12, the term person means an ultimate parent entity, and all entities which it controls directly or indirectly. And then there's a definition of entities. Means any natural person, corporation, company, partnership. Mm-hmm. So is there a loophole or not?
Well,
and if there is, should we be filling it?
Well, I think almost assuredly there is a loophole. At least there is, I believe, case law to that effect. And as I say, that has been of concern to many people over the last several years. All I can tell you is that the department would certainly be delighted to look at that and talk to you about it.
Should Sir James have filed?
That I don't know, Congressman. I am completely unfamiliar with that acquisition. As I said earlier, we have not received a Hart-Scott-Rodino application, and I really know nothing about the parties.
Thank you, Mr. Chairman.
Mr. Kastenmeier?
Mr. Chairman, I think this testimony may be a waste of time. I have no questions, Mr. Chairman.
Thank you very much, Mr.
Thank
Cannon.
you, sir.
By request, Mr. Goldsmith. Only the red light rule.
Our next witness is Mr. James M. Goldsmith. Mr. Goldsmith.
No other witnesses should be up there. That's where we belong.
No, that's all right. He'll get up. Mr. Goldsmith, without objection, your full statement will be made a part of the record. The committee will come to order. You may proceed.
Thank you, sir. Mr. Chairman, I'm very grateful for your invitation to appear here today to participate in what is a fundamental debate and where the facts, from what I've heard this morning, clearly need to be clarified. Paul W. Litchfield was Chief Executive Officer of Goodyear during the 30 years of its greatest prosperity and growth. He defined Goodyear's job very clearly. He said, and I quote, that job was to build better tires, cheaper, and sell them harder. The current management of Goodyear forgot Mr. Litchfield's lesson. It strayed into industries about which it knew nothing, jeopardizing the very heart of Goodyear's business, its competitive position, and the security of all those associated with it. Let me give you an example. In 1983, Goodyear acquired Celeron Corporation. Celeron operated natural gas transmission systems and also owned oil and gas assets. The price paid was $828 million, plus assumption of debt of $160 million, making a total of nearly $1 billion. This diversification is a dramatic illustration of what happens when management gets involved with things that it knows nothing about. So, Mr. Chairman, I suggest it is worthy of analysis. Firstly, the acquisition of Celeron was announced in February 1983. The average acquisition cost of crude oil has never since exceeded the price of that very month. According to the Department of Energy, the cost was $29.16 per barrel in February 1983. It has dropped to $13.06 per barrel in the second quarter of 1986, which is the last period reported on. Secondly, in June 1983, Goodyear announced that it would build a new 300,000 barrel per day transcontinental pipeline going from California to Texas. This was by far the most expensive capital project in Goodyear's history. And I'd like to suggest, and indeed prove to you, Mr. Chairman, that for Goodyear to build a major transcontinental pipeline was as ill-considered as it would be for a major oil company to build a major tire factory. Business Week, in fact, on November the 28th, 1983, the same year, commented, and I quote, "Goodyear's proposal is regarded skeptically, in part because previous attempts by Standard Oil of Ohio and Getty Oil to build west-to-east pipelines on a similar scale flopped. The size and complexity of this undertaking was so great that normal industry practice would have required that the project be syndicated and that steps be taken beforehand to ensure that on completion sufficient oil would be available to enable the pipeline to operate profitably. As far as we are aware, no such precaution was taken." Now, Mr. Chairman, on June the 23rd, 1983, when the pipeline project was made public, the announcement said, and I quote, "The pipeline is expected to cost more than $600 million. By November of the same year, the estimated figure was quoted at $700 million. On December the 5th, 1983, same year, Reuters quoted the probable cost of between $700 and $800 million. On April the 11th, 1984, the New York Times quoted $900 million. In March 1986, the company's 10K filing with the SEC, a figure is given for $890 million plus capitalized interest, which, on an estimate of interest, makes it about $1 billion. In any case, the project is not complete and has been delayed because of environmental problems in Texas. Furthermore, as a result of the fall in oil prices, there have been less exploration and development of oil reserves in California. That means less oil to ship from California to Texas. So now we don't know whether there's enough oil for the pipeline to operate profitably for years. And then in December 1985, Goodyear went in still deeper and purchased further oil and gas properties for $480 million. This time, Mr. Chairman, it was only weeks before the oil price collapsed. So far, Goodyear has recognized a pre-tax loss of $214 million on its oil and gas reserves. Perhaps, Mr. Chairman, Goodyear could afford to squander hundreds of millions of dollars of shareholders' money. But what it could not afford was to cease concentrating on its real business, which, as Litchfield has stated, was to build better tires cheaper and sell them harder. Indeed, Mr. Mercer stated with pride that the acquisition of Celeron would make Goodyear, and I quote, up to 44% non-automotive. That is how management lost its way, Mr. Chairman. The approximately $2 billion spent in the oil and gas business should have been invested to build the most modern, state-of-the-art, frontier-breaking industrial infrastructure, to produce better tires, cheaper, and to ensure that Goodyear's operations could compete with anything, including imports, no matter their origin. Instead, the market share for imported tires rose from 12% in 1982 to 24% in 1985 in the replacement tire market. We all know that Goodyear has the market share, technological leadership, broad strength, distribution network, and management depth needed not only to compete in the U.S. against imported tires, but to dominate them worldwide. But to do so, management must concentrate on the core business and not try to escape from it. Mr. Chairman, a few years ago, a survey was carried out among entrepreneurs in Silicon Valley. And from all we've heard today, I want to give you this example. They were asked whether the government could help to reduce the mortality rate of new enterprises, for example, by offering subsidies. The majority of the entrepreneurs questioned answered that that would be negative. When a new company fails, they said, it is because the management team was wrongly assembled in the first place. If so, the team needs to be disbanded and should regroup into new teams which can be successful. Subsidizing inefficient teams only consolidates inefficiency and hinders innovation. That is the view of the entrepreneur. The view of the corpocrat, Mr. Chairman, as the corporate bureaucracy is now known, is very different. The corpocracy, sorry. When the free market exerts pressure on his corporation, he calls on government for help. If it is the free capital market which is disturbing him today, then he comes to you to ask for new legislation to protect him. If it is the free marketplace for merchandise, he comes to you for trade protection or asks you to exert pressure on exporting countries so that they can impose voluntary restraints. Goodyear is no exception. This committee hearing is the first step in asking you for protection from the free capital market. In August 1984, Goodyear, along with others, asked for protection from the free market for merchandise. They signed a request to the U.S. Commerce Department to restrict imports of tires. The reason given was that importers were dumping. The Commerce Department rejected the claim. Instead, the Korean government voluntarily imposed restraints on exports to the U.S. by Korean tire manufacturers. The appropriate response, Mr. Chairman, to competition is to compete, not to seek artificial protection. That means reorganizing, cutting out fat, and concentrating on building better tires, cheaper, and selling them harder. During the past week, Mr. Chairman, on television, in the newspapers, and in public meetings, Goodyear management and their friends have sought to raise strong feelings about me. The Congressman Seibling mentioned some of those facts today. I'd like you, if you'd be so kind, to let me analyze their rhetoric. Firstly, they point to the fact I'm a foreigner. Whether or not America welcomes foreign investment is a question not for me. It's a question that the administration, Congress, and the American people must decide. For my part, I've always campaigned in Europe for the freedom of foreign investment. But it seems to me, Mr. Chairman, that Goodyear's views have been the same as mine. That is, until the last few weeks. Goodyear is justifiably proud of operating 101 manufacturing facilities in 28 countries, Mr. Chairman. That means that Goodyear has believed foreign investment to be right for at least 27 countries. Secondly, they suggest that U.S. subsidiaries of offshore corporations like ours pay less tax than U.S. companies. In reality, when we invest in the U.S., our operations are subject to U.S. tax regulations like everybody else. Grand Union, our supermarket company, pays the same taxes as Safeway. Our forest products company pays the same tax as Weyerhaeuser. Thirdly, and to heighten the tension and create anxiety, they claim that we would sell and that I would dissipate Goodyear's assets and cause loss of jobs. pretty stupid that I would dissipate. We're suggesting putting up $1 billion in our equity, Mr. Chairman, and the total management investment in the company at this time, in terms of share ownership, is $8 million. So why we would dissipate with $1 billion invested, as opposed to the present management with $8 million invested, is somewhat unclear to me. But, yes, indeed, we have made it clear that we would return Goodyear to its core business and concentrate on it. And that means selling non-core diversifications. Goodyear management has now announced it will do the same thing. Selling diversifications does not mean dissipating assets or jobs. And this, Mr. Chairman, is where I take particular exception to much of what has been said today. It means transferring activities from the hands of management with inappropriate experience into those with appropriate experience. Normally, this results in greater growth and prosperity for the companies concerned, thereby benefiting employees, shareholders, companies, customers, and communities. And I would like to explain.
I want to cut you off, but we do have a number of other witnesses. If you could sort of
I know. I'll go as
conclusion.
fast as I can, Mr. Chairman. I did, in fact, warn that to place my case, I had to go a little further. But I really wanted to give you one, if I may, Mr. Chairman, documented case history, as quickly as I can. It's a documented case history which proves what I've just said. In 1982, we acquired a company whose origins were also in Akron, Ohio. The company was a Diamond International company, which was known as the old Diamond Match Company. Diamond's core business was in the forest products industry. It had diversified in a number of other areas. We decided to concentrate on the core business and improve it and sell the other divisions. And I think it's interesting, Mr. Chairman, to see what actually happened. It's 4 years now. We can now know whether the selling off of divisions is rape, dissipation, and spoliation, or whether, on the other hand, it is something else. And we've got the facts for you here today. I've assembled them for you, Mr. Chairman. 2 Ohio companies, and these gentlemen who represent Ohio will be able to check the facts. 2 Ohio companies, the U.S. Playing Card Corporation and Hekin Can, were sold to investor groups, the latter including management. Since that time, the U.S. Playing Card Company has prospered. It has increased capital investment substantially, enabling it to acquire another company in its own industry, and it now employs 25% more people. The sales of Hekin Can have almost doubled. Operating income has grown from 10 million to 25 million. Employment is up over 20%. One company, Kalmar Incorporated, a maker of consumer pumps, became independent by going public. Sales have risen by over 50%. Kalmar is building new plants. Overall employment is up 25%. In its Ohio plant, employment has increased over 15%. The packaging division of Diamond was sold to Jefferson Smurfit, a company which concentrates on that industry. At the time we sold that division's principal mill, located in Middletown, Ohio, was in deep financial trouble. Since the sale, production at that mill is up 50%, wages and benefits are up 33%, capital investment has increased fourfold. Sulzer Weiss, a machine manufacturing company located in Monroe, Ohio, was sold to its joint venture partner. Sales have doubled, employment is up by 25%, capital investment is up by 700%, etc. I won't go through them all, Mr. Chairman. That is what happens when companies are liberated from tired conglomerates. And this is only one example among many. Up and down the country, hundreds of erstwhile stagnant divisions of large bureaucratic corporations have been freed. And this means that either the life-giving link of ownership and management is restored, or that single industry management is able to concentrate on managing a business it understands. The result is not dissipating assets. The facts are available, and I would recommend that they be studied before adopting the usual knee-jerk opposition to free market capitalism and support for the bureaucratic establishment. Finally, Mr. Chairman, Goodyear also makes the usual claims of the corpocracy that the market is unable to recognize stock market, that is, long-term values, and forces management to concentrate on the short term to the detriment of the long term. In other words, that the market only measures short-term profits and disregards items such as research and development. But the opposite is true, and it's quite evident for everybody to see. If that were true, Mr. Chairman, all earnings, regardless of quality, would be multiplied by the same price-earnings multiple. But the opposite occurs. The market applies vastly varying price-earnings multiples. Why? When the market believes that management is good and that earnings will grow, then it places a premium on the market price of the shares so as to take into account future growth. When, on the other hand, the market believes that management is poor and will dissipate earnings and assets, it places a discount on the market value of the shares so as to take into account future stagnation or decline. If Goodyear management has failed to convince the marketplace that it deserves a good rating and instead receives a poor one, then it has only itself to blame along with its failed strategy. I now come to the end, Mr. Chairman. Thank you for your courtesy. Mr. Mercer, in a letter to Goodyear employees, stated that I was responsible for introducing, and I quote, this corporation to a new and not very pretty world. What he means, of course, is the rough and tough world of competition. A world in which you just don't throw away hundreds of millions of dollars chasing after scatterbrained dreams. A world in which you run a business as a business, Mr. Chairman, and not as an institution. In fact, what Goodyear management is doing a corporate fat that has been allowed to build up around the core business. For the last 2 weeks, it has been frantically discovering waste almost every day and announcing it's now doing the business it's supposed to have been doing. Mr. Mercer is an honorable man. He would not reorganize the company if he did not believe it to be right. If management finds it easy to hide behind me to do the job for which it has been paid and which it has failed to do, then so be it. That is the role that an active investor must be willing to assume. At least one way or another, the company will return to the business it knows and will concentrate on it so as to remain globally competitive. That, Mr. Chairman, not rhetoric, is how Goodyear, its shareholders and employees, will be best served. Thank you for your patience, sir.
Thank you, Mr. Goldsmith. Mr. Seiberling.
Thank you, Mr. Chairman. Mr. Goldsmith, you were interviewed by the Akron Beacon Journal and published the transcript of that interview on November the 6th. And in that interview, you stated, I certainly don't pretend to know the tire business. Now you are saying that you do know more about the tire business than those who have been in it for many years, apparently, because you're deciding how Goodyear ought to operate. And my question is, who the hell are you?
Mr. Seiberling. Mr. Seiberling, I too will clap, because I think the question as posed deserves applause, but is wholly misleading. First, let me tell you why it is misleading. I made it quite clear in this document, Mr. Seiberling, that I was an active investor, and I'm happy to define what I consider to be the role of an active investor.
Well, I hope you'll make your response brief.
I will do it by this answer, and I hope it'll be clear to you. An active investor is not a manager. He is not a particularist. He's not a man who thinks that he can double-guess management. He's not a person who thinks that he can do the job of management better than the manager that he can hire.
But that's exactly what you're doing.
I'll tell you what. No, sir, it is not. What I'm saying is an active manager has to ensure that the right management has to be in place, number one. That the right management has to be properly motivated, number two. That the right manager, properly motivated, then runs the company according to a reasonable strategy and not trying to chase after all sorts of industries it knows nothing about. That is the job of an active manager, an active investor. If he does not consider the management right, he fires it and replaces it.
You also, in the same interview, are quoted as saying, Goodyear is clearly the best tire company in the world. It shows by its market leadership, by its brand leadership. It has the strength of research and technology. And, of course, that's absolutely true. And Goodyear has not apparently injured its core business, the tire business, by diversifying into aerospace. As a matter of fact, it's been in it since World War I. It hasn't hurt it by going into Celeron, which was financed by other means. So I really think that you are making a lot of inconsistent statements here about an industry that you admittedly you know nothing about.
Well,
and I would like to now get into another aspect.
No, sir, could I answer
Yes,
those
certainly.
points? I feel I need to answer those. You said that they couldn't harm themselves by buying Celuron, which was financed by other means. What you mean is borrowing money, Mr. Congressman. And Congressman, when you borrow money, you have to pay it back. So you can damage yourself when you take a debt and invest the proceeds poorly. So I think that was a misleading statement, and I'd like to put it right. The second point is, you say, and I did say, that I believe that Goodyear is the best tire company in the world. And I do, because it has the technology and the management. But is it compatible for the best managed tire company in the world to have to come to government to seek protection from foreign imports? If it was truly the best, as it could be, by concentrating on its business, it would be other countries that would be seeking voluntary restraint from Goodyear, not the other way, Mr. Congressman.
Well, thank you. Now we get into the question of borrowing money. I understand that your cost for acquiring Diamond International was $661 million. I presume most of that was borrowed money.
I can't remember how much we borrowed.
Well, I don't blame you. I'd be sort of...
We borrowed about 2/3 of it, I'm told.
I see. Well, in any event, I'm looking at a chart from the Fortune magazine of October of 1983 entitled Completed Divestitures of Diamond Division. And it lists all of the different divisions that were sold and were pending, sales were pending, and then the remaining assets, which were timberlands and percentages of a couple of companies. The total value of this was listed in Fortune as $1,326 million. Subtracting your cost of acquiring it as $661 million, and adding to that Diamond's corporate debt of $162 million, and then it lists Goldsmith's potential gain, $503 million. Now, I presume that the purpose of your acquisition of this company was to end up with a profit for yourself. Isn't that really
I can think
your
of
interest?
no other reason for doing business.
Well, of course, and this wasn't done to improve the company's particular status in all these different markets that they were in. It was to make money for Mr. Goldsmith.
And I strongly recommend that the United States, which was built on that idea, remain on that idea.
But
it's very worthwhile. It's built into a great nation, Congressman.
Do you recognize any obligation to the communities, the employees, and the people of the United States themselves?
Mr. Siebeling, not only do I recognize it, I have delivered. I've just given you the example. In every case you've mentioned, the result has been to strengthen the company, to strengthen employment. We have delivered on that promise. I'd like to see others, bureaucratic companies, who've delivered as well. Perhaps you will produce such a company to match this one.
Well, let me ask you this with respect to Crown Zellerbach Corporation. I understand that the restructuring that you brought about when you acquired control netted you about 1.9 million acres of timberland, which I'm told were valued at over $1 billion, and that the remainder of the company, including its paper business, was sold, and that they lost hundreds of employees in the process.
This is an excellent example. Firstly, on these big profits you talk about. If Fortune magazine or the people who told you about these great values are about, maybe they'd like to make us an offer. We could do a deal after the meeting. Secondly, we have not realized these profits. These profits are latent. One day we might realize them, but they are long-term. We haven't so decided. Long-term investments. And if we do realize them, we will pay corporate tax like everybody else.
Well, did one of the...
Now, let me, if I may, just go on the second point that you mentioned, which was Crown Zellerbach, that there were people who lost their jobs in Crown Zellerbach. Now, where did they lose their jobs? Most interesting example. One of the companies that we took over, Congressman, was a company called Excel. And Excel was a company which distributed high-tech goods to offices. And it was losing under Crown Zellerbach's management between $17 and $20 million a year. And Crown Zellerbach management had decided to close that business, Congressman, and to eliminate all jobs associated with it. We went in and said, let's give it a try. Let's try and apply decent management practice. That'll mean some surgery, it'll mean some bleeding, but can we save the patient? So we went there and we carried out surgery. And I'm glad to tell you that next month it's expected it'll break even, and next year it's expected it'll make a profit. And we saved the jobs that were saved by entrepreneurial management as opposed to by a bureaucratic write-off on a one line as an exceptional item.
Is it true that one of the entities just recently issued to you, one of the Crown entities, a special dividend of $213 million?
That is correct, and I hope there'll be many more.
Well, I don't blame you. I just think that the record, however, shows that the patient that you say was saved doesn't feel saved.
Well, Mr. Congressman, maybe you haven't met them, and maybe before jumping to yet another prejudiced conclusion, you actually try and check the facts. They will be made available to you if you'd like it.
Well, the chairman advises me my time has expired. Thank you very much.
We now leave this program to bring you a program schedule update. We'll be back with a look at the schedule after this. You're watching C-SPAN, America's Network.